Islamic jurisprudence is known as fiqh, which literally means deep understanding or comprehension. It refers to the human effort to derive and understand the practical legal rulings, sharia, from the detailed Islamic sources. The entire structure of Islamic jurisprudence is built upon a well-defined hierarchy of sources. This science of the sources and the methodology of deriving rulings is called usul al-fiqh, the foundations of jurisprudence. Here is a detailed breakdown of what Islamic jurisprudence is based on, from the most authoritative sources to the supplementary ones. The primary sources, al-adilla al-asliya. These are the universally accepted fundamental sources from which all rulings are derived. 1. The Quran. What it is. The divine, verbatim word of Allah as revealed to Prophet Muhammad, pbuh. It is the supreme and unchallengeable source. Role in jurisprudence, it provides broad principles, foundational commands and prohibitions, e.g., establishing prayer, giving charity, prohibiting usury and adultery. Specific laws, detailed rulings on matters like inheritance, marriage, and divorce. Moral and ethical guidance, the overarching spirit and objectives of the law. Characteristic, its rulings are definitive and absolute, qat'i. However, many verses are general, requiring the sunnah for clarification and specification. 2. The sunnah. What it is, the sayings, actions, approvals, and physical and moral characteristics of Prophet Muhammad, pbuh. Role in jurisprudence, it is the living explanation and practical application of the Quran. Its functions are to confirm Quranic rulings, reinforce what is in the Quran, to explain and clarify the Quran, detail general commands, example, the Sunnah shows how to pray, not just the command to pray, to specify generalities, apply a general Quranic rule to a specific situation, to establish new rulings, introduce laws not explicitly mentioned in the Quran, but which have the force of divine revelation. Basis. The Quran itself commands obedience to the Prophet, pbuh, and whatever the Messenger has given you take, and what he has forbidden you refrain from. Quran 59:7. The secondary, dependent, sources. These are methodological tools used by jurists to derive laws when no clear text from the Quran or Sunnah exists. Their acceptance and application can vary between different schools of law, madahib. 3. Ijma, scholarly consensus. What it is. The unanimous agreement of the Muslim jurists, mujtahids, of a particular generation after the death of the Prophet, pbuh, on a specific legal ruling. Role in jurisprudence, it provides certainty on matters where the primary sources may be open to interpretation. Once an ijma is established, it is considered a definitive proof. Example, the consensus on the compilation of the Quran into a single musahaf. 4. Qiyas, analogical reasoning. What it is. The process of deducing a ruling for a new situation by comparing it to an original situation mentioned in the Quran or Sunnah, based on a common underlying cause, illah. Role in jurisprudence, it is the primary tool for addressing new and contemporary issues. The process, the four pillars of qiyas, al-asl, the original case, the case mentioned in the texts, example, drinking wine is prohibited. Al-far, the new case not explicitly mentioned, e.g., consuming cocaine. Al-illah, the effective cause, the common reason behind the ruling, e.g., intoxication, which impairs the mind. Al-hukam, the ruling, the law is transferred from the original case to the new case, e.g., cocaine is also prohibited. Other important sources, varying degrees of acceptance. Different schools of law employ some of these additional sources. 5. Istihsan, juristic preference. Definition: setting aside an established analogy for a stronger, more equitable one based on a stronger evidence from the Quran, Sunnah, or public interest. Used prominently by the Hanafi school. Example: a contract of salam, advance payment for future delivery, is technically an exception to the rule against selling what one does not possess, but it is permitted based on istihsan due to clear human need. 6. Maslaha mursala, consideration of public interest. Definition: deriving a ruling for an issue not explicitly covered by other sources, purely on the grounds that it serves an undeniable public interest and does not contradict any established Islamic principle. Used prominently by the Maliki school. Example: the decision by Caliph Abu Bakr to compile the Quran into a single book after the death of many memorizers in battle. This was done to protect the religion, a clear public interest. 7. Urf, custom. Definition: widespread, recurring practice among people that is not in direct conflict with a primary text. It can be used to specify the general meaning of a text. Example: the definition of a fair dowry in marriage is largely determined by local custom. 8. Istishab, presumption of continuity. Definition: the principle that a state of affairs known to exist in the past or present is presumed to continue until there is evidence of a change. The default state of all things is permissibility. Application: the principle of innocence until proven guilty is a form of istishab. 9. Sad al-Dari, blocking the means. Definition: prohibiting something that is otherwise permissible because it is a clear and probable means, wasila, to a prohibited end. Example: speaking to a non-mahram woman for a legitimate need is permissible, but a flirtatious conversation is prohibited because it is a means leading to fornication or adultery. Summary: the process in a nutshell. When a jurist, faqih or mujtahid, encounters a new situation, the process of deriving a ruling generally follows this hierarchy. Look for a clear text in the Quran. If not found, look for a clear text in the authentic Sunnah. If not found, check for a valid scholarly consensus, ijma. If not found, apply analogical reasoning, qiyas. If needed, employ other supplementary methods, like istihsan or maslahah, depending on the jurist's school of thought. This entire structured methodology ensures that Islamic law remains firmly rooted in its divine sources while being capable of addressing the ever-changing realities of human life.